Hello everyone, bonjour tout le monde. Je veux discuter le développement récemment de Bill C-16, the Protecting Victims Act. Maybe just before I get into the reason for being here, just to offer a refresher on how important the Protecting Victims Act is to the well-being of Canadians, and particularly to combating gender-based violence and the exploitation of children in an online environment and in the real world. This bill, of course, is going to criminalize femicide, hate-motivated murder against women to result in a constructive first-degree murder charge. It will create a new offence of coercive control, allowing the legal system to intervene, particularly in violent relationships, before that violence becomes fatal. It has several new measures that are going to modernize the criminal code, both in terms of the reforms to the charge of criminal harassment, but also the new offence of the non-consensual sharing of intimate images created by artificial intelligence. The use of deepfakes in particular is of increasing concern with the prevalence that we're seeing in communities across the country. There's obviously measures as well to shrink the time it takes to bring matters to trial, including in sexual assault cases, and a renovation of the Victims' Bill of Rights, significantly to provide a clearer voice for victims in the criminal justice process. Aujourd'hui, nous prenons l'étape pour accélérer l'adoption de ce projet de loi très important, juste dans la Chambre des communes maintenant. I want to share with you some of my motivation to accelerate the adoption of this bill. I was just last week, some of you outside the cabinet or caucus room, I can't recall which scrum, asked me about the urgency to get this done and the work of the Senate in particular. And I should say the Senate have been excellent partners on the justice portfolio. They have in some instances been sitting outside of their normal hours, sometimes during non-sitting weeks, including an appearance with me virtually. I appeared at the Senate last week and took questions on the importance of accelerating this bill and whether we wanted substantive discussion or the rapid acceleration. I don't know that it's an exercise in choosing between them, but after I discussed the importance of accelerating these measures, specifically to address the rising concern of the use of AI deepfakes, I got home and was greeted with a news article from my home province of another case of an individual facing 79 charges tied to specifically the use of artificial intelligence to circulate heinous images of women without their consent performing sexual acts which did not take place in reality. When I read the article this morning, the Ottawa police who were involved in the investigation drew specific attention to the fact that this case was made more difficult because the charges contemplated in Bill C-16 are not yet part of Canada's laws. This reflects commentary that we've seen just weeks ago, including from a judge in my home province of Nova Scotia, who was not able to convict a person for this absolutely heinous behaviour, and specifically mentioned the fact that AI deepfakes do not constitute intimate images for the purpose of Canada's criminal laws. We have an opportunity to build upon the robust study that took place at the Justice Committee, to build upon the feedback that stakeholders from across Canada have asked us to implement, and to further consider measures not only in the debate that remains in the House, but at the Senate over the next number of weeks. The decision that is facing Parliament today is whether we want to immediately take steps to offer these protections to people who would potentially become victims. My suggestion is that now is the appropriate time to act. Yes, we can conduct our studies. Yes, we can propose necessary amendments, but we cannot delay justice for people who've been denied. Il est essentiel pour prendre la prochaine étape, incluant adopter Bill C-16 pour protéger les victimes de crimes partout notre pays. Ce n'est pas OK pour juste rester pour l'été. C'est OK, c'est un problème pour l'automne. Ce n'est pas acceptable. If it is possible to have this bill form part of Canada's criminal laws, it's incumbent upon every parliamentarian, in my view, to do everything within their power to accelerate these important measures. Merci tout le monde, c'est un plaisir d'ici. Je suis très heureux de prendre vos questions.
How far should he go when it comes to the overall AI generation of sexually explicit material beyond just deepfakes targeting individuals in reality? Should it be legal in Canada for AI image generation programs to create sexually explicit material of any kind?
That's something that's the subject of a debate that's helping influence C-16 and potentially the final version of C-16. To start, the problem that we want it to cure was the fact that there was a dissonance between what the law said and the reality that people are living through. More specifically, intimate images, as defined in the criminal code, did not include those generated through the use of AI deepfakes, and the sharing of those intimate images, which reflects the crime that exists on the books today, needed to be updated so we were treating AI deepfakes on par with intimate images that were taken in the real world but shared without consent. There is a debate playing out. I don't want to prejudge what potential amendments the Senate may propose, but whether it would be more expansive to include the creation and not only the sharing of these images is something that I invite senators to consider, and will consider with an open mind should they choose to make such an amendment.
Well, talk about what happened last week at the Senate. Senator Denise Batter said it was, you were treating the Senate like a rubber stamp by giving them basically 2 weeks to pass this bill forward. You mentioned all the different clauses, the different parts of it. Do you agree with that criticism that this is maybe too complex of a bill to get through the finish line in the 2 weeks we have before the summer recess?
I don't want to suggest to the Senate there's some preordained outcome here. We want to consider in good faith what amendments they may actually propose that they feel are necessary to the adoption of the bill. But I also want to impress upon them the urgency of moving in this particular down this particular path as quickly as we can. With enormous respect to the Senate, who I think could fairly say we want an opportunity to do our job. It is a difficult pill to swallow coming from somebody who belongs to the Conservative caucus, having watched their deliberate filibuster for months of the Justice Committee on the House side. When we discussed that filibuster at the time months ago, I personally raised with colleagues on the Justice Committee the need to get moving because they were in fact slowing down reforms on bail, on sentencing, on gender-based violence, on sexual exploitation. Several months down the road, we are precisely where I discussed we would be in those conversations. I wish I was wrong about that, sincerely. But it's very clear that when I see members of the Conservative caucus say there's not enough time to deal with this, knowing that they wasted the time that they were given at the Justice Committee in the House of Commons, it is a difficult criticism to accept. There are other senators who have raised with me their desire to do a robust study. I'm not asking them to take shortcuts, to be clear. If they need accommodations to sit additional hours to get this done, that is something that is within their purview. My message to all parliamentarians, not just senators, by the way, who I want to stress have been excellent partners, not only sitting outside of ordinary hours, not only sitting during non-sitting weeks, but even moving certain bills to different committees to clear space on the legislative agenda. They are doing their part. They deserve an opportunity to make meaningful suggestions on how the bill can be strengthened, and I believe Canadians could benefit. But given what's playing out in our communities every single day, we can't afford a months-long delay to have these protections benefit victims. When the police are asking for it in the news, when judges are declaring the need for relief from the bench, it's incumbent, in my view, upon Parliament to take action, and to take action today.
There's one piece of this legislation that would address the thing that judges and police are saying need to change that has broad consensus. Would you consider splitting that out from the rest of the bill and allowing it to pass quicker?
Well, I don't think that there is a lot of controversy when I have conversations with parliamentarians from different parties about the substance of the bill, with perhaps the one limited exception which the Conservative has raised with relates to the response to the Senate bill decision. The rest of the bill, by all accounts, has a broad base of support. And though there has been a desire expressed by certain parliamentarians to dig in detail, it's not coming from a place where there is substantive opposition to the measures contained therein. If we were to split that one portion of the bill to address the acute concern that was raised with me and in the news over the past few days, we would still be delaying relief when it comes to coercive control, when it comes to the first-degree charges tied to femicide, when it comes to criminal harassment, including modernization of the way that crime is being committed with the use of GPS as a tracking device on people's phones, including measures tied to the sexual exploitation of children online, including delays in the justice system, including the Victims' Bill of Rights. This bill has more than 80 substantive measures, all of which are extremely important. I cite the example of AI deepfakes, and not because it is the most important compared to these other important measures, but because the example has presented itself just days ago. If we wait a few more days, there will be other examples in these other policy areas, and we can prevent this harm from taking place in some instances, or potentially ensure that the criminal law has full force effect on the perpetrators of the crimes that may take place in the number of weeks ahead. So I'm not entertaining splitting this bill at this point in time, because I believe the impact of that decision would be felt not by politicians on Parliament Hill, but by victims of crime and communities.
I know Monsieur, votre gouvernement a
Plus
déposé...
lent pour mes oreilles, s'il vous plaît. Ouais.
Votre gouvernement a déposé aujourd'hui sa stratégie sur l'intelligence artificielle.
Ouais.
Déjà, on entend des gens dire que c'est trop vague, qu'il n'y a pas de garde-fou par rapport à la vie privée, à la protection des enfants. Qu'est-ce que vous répondez à ces critiques?
Il y a beaucoup de mesures qui concernent l'intelligence artificielle. La stratégie maintenant c'est un framework en anglais pour les politiques que le gouvernement a avancées dans les prochains mois, dans l'avenir. Ce projet de loi a les politiques spécifiques pour adresser un problème social qui est réel dans nos communautés aujourd'hui. La stratégie incluant des mesures dans l'avenir pour le privé les Canadiens, pour protéger la façon que les enfants utilisent les nouvelles technologies. Mais c'est une chose similaire, mais une politique plus spécifique qui est dans C16. I think we have an opportunity to move forward with both in parallel, but you should expect, to the extent you have concerns about the national strategy being vague, these strategies start out with a broad framework and are typically followed by specific policies that breathe life into the principles and ideas that suss out the flesh of the framework.
I know with C16 it has been amended to allow a court to order a company to take down an image within 48 hours, and BC has something similar in place. What's your level of confidence that tech giants and platforms would listen to what a Canadian court would order to remove someone's sexualized deepfake of themselves from that their platform might be hosting?
I feel very fortunate to live in Canada when we're faced with questions of this regard. I have enormous confidence that the courts are going to uphold and enforce the law that is adopted at various levels of government in this country. The players in industry, not just technology but more broadly, have a responsibility to follow the laws in the jurisdictions in which they operate. They should expect, to the extent that governments adopt laws, not just this one in particular, that those laws will in fact be enforced. But in my conversations, which again, the relationship with a lot of the tech companies is being led by colleagues, so I won't speak for them, but in the conversations that I have had, they want the same thing. They don't want their users to be at risk. They want to comply with the laws. To the extent that they have very real concerns that they want to talk through, I found that we've had an open opportunity to engage. I expect the same is true with other offices within the federal cabinet. But my message to them would be follow closely the laws that are being adopted, understand the motivation for what we're trying to achieve, in this case, protecting the interests of victims who've been had their likeness used to be exploited sexually online, and ensure that to the extent that there are unforeseen consequences, not of what we're doing, but the way that we're doing it, that we understand those early in the process.
And do you think there's a room for regulation of these companies to deal with the issue of sexualized deepfakes? Not just the criminal tool, which you're responsible for, but a regulating of these tech companies.
So it depends on what aspect you're dealing with. Obviously, the criminal law is going to be applied against the perpetrator. This is a separate issue. I do think that there is space in the regulatory context to develop some more certainty as to what the expectation is. But my own view is that if a person's likeness is being used to have sexual imagery put on the internet without their consent, we should not only be seeking to punish the perpetrator of such a heinous act, but also providing real relief to the victim, including wherever possible, the right to have that material deleted.
Does this strategy risk further inflaming trade tensions with the U.S. because you're talking about creating your own sovereign cloud, watermarking all AI-generated content? So has this not risk further inflaming those trade tensions?
Look, just on the AI strategy specifically, talking about my own responsibilities in the criminal piece, I would defer to Minister Solomon. Suffice it to say, when we develop policies, the interests of Canadians is what determines the decisions that we're going to take. The well-being of communities in this country demands, in my view, that we adopt a certain level of sovereignty to artificial intelligence as this new sector emerges. We want to make sure that we have an opportunity to be in control of our own destiny, and to the extent that sovereignty and AI is going to be part of that conversation, know that it's going to be the interests of Canadians, not exclusively potential trade irritants, that's going to dictate Canadian policy.
Mais on vous a vu faire des reculs.
Juste une personne qui n'a posé une question, juste ici.
Will the deepfake measures outlined in C16 be complemented in any way by non-criminal measures in an updated privacy law?
So I don't want to violate what privileges may exist by discussing what could or could not be in a specific piece of legislation, but we will look at different opportunities to both protect privacy, to provide relief for victims whose likeness is used, and to pursue criminal charges at the same time. In addition to very specifically dealing with AI-generated images that need to be criminalized or regulated as may be appropriate, there are other social needs that we have to address some of these problems more broadly. We have community organizations that are doing incredible work to teach young men about what consent means in this country. Having programs not just through Justice Canada, but through, I think Minister Valdez is here somewhere, through Women and Gender Equality, to actually help ensure that we're going upstream, teaching people about healthy relationships from an early age, making sure that we have social supports in place that build healthier people and stronger communities, has all got to be a part of the strategy. So specifically on your question on the use of AI, yes, there's a role for criminal law. Yes, there's a role for other legal measures that can be put in place around privacy, around regulating the behavior of players in the tech sector more broadly. But you have to take a long view of how you're going to end this behavior, and that includes that we look at the underlying social challenges that help proliferate this kind of egregious behavior as well.
So, Mr. Fraser, you mentioned the 79 charges against Stephen Lowe earlier, but of course these deepfakes and this problem has existed for many, many years now. Mm-hmm. Should the government have acted sooner?
So, look, yes, but let's actually look at why we haven't. This was a campaign commitment during the last federal election campaign. We went to work over the course, of course, the cabinet having been sworn in May of last year. We went to work over the course of the summer in our department, obviously generating 3 bills in short succession on our anti-hate bill, bail and sentencing reform, and of course the gender-based violence bill, the Protecting Victims Act. When we came back in the fall, all 3 bills were tabled very quickly. The reason for the delay, to the extent there has been one, is the filibustering that took place at the Justice Committee. This could have been done months ago. Is it possible that there could have been action taken years ago? Perhaps, but I would point out the proliferation of the technology has accelerated and continues to accelerate. It is a bigger problem today than it was yesterday. It is going to be a bigger problem tomorrow than it is today. Though the tool may have existed, we weren't necessarily seeing it to the degree that we're seeing today, even after we made the campaign commitment. So you can always, with the benefit of hindsight, say we should have done a good thing at a different time, but it is never the wrong time to do the right thing. And I would urge all parliamentarians to do the right thing today.
So there are 25 alleged victims of Mr. Stephen Lowe, the case you were just referring to, and over a 5-year period it happened, as I said in the past. So what would you say to those alleged victims about this legislation and the action the government is taking now?
I'm just so sorry that people have to live through this. Think about their lives and what has changed for them day to day. They don't know who's seen these images. They don't know for what purpose they were used. This is monstrous behavior. We're going to do something about it. We want everyone to do something about it, not next year, not next month, today. We have literally just accelerated the debate on this issue in the House of Commons, partially because of the cases that they have been involved with. We need to move as quickly as we possibly can, not just to provide comfort to the victims of this particular perpetrator, but to demonstrate that this doesn't have to happen to other people. If victims of crime have communicated one thing to me, it's that yes, they want to share their experience so policymakers understand, but overwhelmingly across a wide variety of policy areas, they don't want other people to have to live through it. We can prevent that from happening, but it's going to take all of us and it's going to take action today. Merci tout le monde. Merci.